public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up in the back. All right, third item on the agenda is approval of the public session meeting minutes from our June 7th, 2024 meeting. Is there a motion to approve those public session minutes?
So moved.
Second.
All in favor? Aye. All right, moving on to item 4 is the report on electronic filing. With the July 1st disclosure deadline behind us this morning, we've set the e-filing report to lead off our meeting. So I'll turn it over to Carrie.
So that they can hear me. Good morning and thank you. As the chair mentioned, we're currently past the July 1 deadline, and we all live to tell. We're in the grace period until the September 3rd deadline, after which time fines accrue at a rate of $25 a day for each day late, up to $1,500. At the last meeting, you'll recall that roughly 50% of reporting individuals had already filed their form. In the month of June, our office had 9,229 incoming calls. You'll recall that these calls aren't necessarily all unique. The actual number of individuals contacting us would have been lower. There's no way to distinguish how many of the incoming are return or repeat calls, but in May we had 5,000 or so calls. So we were definitely in the business. And we can say for sure that 3,711 of those calls were routed to our call center for assistance. The system was set up and running the entire disclosure season, and aside from some minor bugs and technical issues, it performed as expected, even during the week leading up to the deadline, where we saw about a little over 5,000 forms filed electronically during that 1 week. I think it's safe to say it's been a pretty successful launch, all things considered. Anecdotally, we've received a lot of positive feedback on the system concerning filer experiences with it. Of course, the most difficult task remains assisting filers who serve on boards, who might have limited access to technology or limited experience with technology, as well as the issue of having valid email addresses and getting folks logged in. Some filers did not like having an electronic system. They did not like not being able to file paper as they had before. We expected that. We did have some that did not like the fact that the comparative threshold manner of reporting financial interests that was on the paper form was no longer as a part of the e-filing system when the legislature streamlined it back in 2019 once we went electronic. It's just that dollar value threshold that people have in order to file disclosure. But we made it through that part, and then we had a curveball when the federal court handed down the temporary injunction concerning the litigation on the local commissioners and mayors filing the Form 6 instead of the Form 1. That happened the Monday after our commission meeting on the afternoon of Monday, June 10th. It was qualifying week for candidates seeking to qualify for office. So this was significant in terms of implementing this system because EFDMS ties the form requirement to the public position of the filer. So for candidates who do not otherwise hold a position requiring the filing of financial disclosure, but who need to file a form to qualify for office, the system has a form picker where they will use a drop-down list to select the position that they're running for, and based on the position they're seeking, the system populates the correct form onto their dashboard. So you can understand how this created a situation for us that we had to remedy. This is also true for folks who currently hold a position who might be running for another office. Their ability to pick a different form than what the system had them tagged to file and get that form to reflect the correct information such that a qualifying officer would accept it, all of that had to be reprogrammed. So we had to marshal resources very quickly that week, not only to evaluate, program, test, and then push into production all of the necessary changes to comply with the court's order and ensure that any person who wished to qualify for office was able to complete and file the required financial disclosure form by noon on that Friday qualifying deadline. We did push those necessary changes just after close of business on Tuesday, and updated information to our main website Wednesday morning. We communicated important, pertinent information about the injunction and its impact to financial disclosure to filers and qualifying officers, with a big assist from stakeholder organizations like the State Association of Supervisors of Elections, as well as the Florida League of Cities. We are not aware of any person who is not able to qualify for office due to an inability to access and complete the disclosure form in EFDMS. As of yesterday, 90.69% of state Form 1 disclosure filers had filed their form. Nearly 85% of local filers, other than city commissioners and mayors, had filed, and about 88% of city commissioners and mayors had filed their disclosure in terms of Form 1. Overall, Form 1 compliance rate sits at 87.19% as of yesterday afternoon. That's 31,446 disclosure forms out of a total of 36,065 expected Form 1s. There are only 99 Form 6 non-judicial filers who have not yet filed out of a total of 1,391. So that's just under 93%. And overall compliance for Form 1 and Form 6 sits at 87.4% currently. We are slightly behind this point last year when we had just over 91% of disclosure forms on file. Given that this is the first year of e-filing, that slight lag at this point isn't surprising. During this time period, the chair approved a number of disclosure extensions, including an extension for those filers who were city commissioners and mayors impacted by the form change. She approved an extension to them, I believe it was to July 15th, so they had some additional time. On Monday of this week, we sent postcards to those individuals who had not yet filed. We had good traction with that when we sent that previously, to sort of notify people that these emails they were getting mean something, and that there was something that they need to do. We're also going to be working with our call center to get calls out to folks who have not filed, and urge them to get filed and offer them any assistance they need in order to file. In past years, we ended up with 98 to 99% compliance, so we have work to do in the coming month to get folks here. It is truly exciting for us to be on this side of July 1st. Our staff has been working on this system since 2019, and Chair Lucas graciously granted my request to invite a few of the key members of the IT team for EFDMS to join us today, and it's my pleasure to introduce them to you. Seated in the gallery, Julie Gowan. She's the IT director and coordinator for the Office of Legislative Information Services, that they serve as our IT people. Tricia Ashley is the EFDMS project lead, the organizer of all stories, issues, questions, concerns, and to-do lists. She marshals resources down there very well. Jessica Biggers is a business analyst for the team, and she has been an integral part of working on the system, and she got up to speed quickly and has been a great help to us. I also want to recognize the other members of the IT team who couldn't be with us this morning because they're back at the office working on the system, because there's still work to be done. Suhail Ghazi, AJ Mookie, Jing Chen, Jenny Chang, Ramia Kavuda, Sada Medea, Sony Singh, Jennifer Reed, Sejwan Wang, and of course, Willie Thomas, who's been a project administrator on this, who's been with us since day one. So if you would indulge me with a round of applause for these people. Not only have they done a great job with the system, but they are the brains and the team who made the magic that week that we had to comply with the court's order, and we're grateful for that. course, I'd be remiss if I didn't thank the SIS admin team, the system administration team at Olitz, who constantly monitor the server technology and actually hopped in their cars on an early Sunday morning to go to the office to address an issue that was not EFDMS related, but was connectivity related and was not the responsibility of our agency or Olitz. And they got that resolved quickly. Last but not least, of course, Bob Endress, the Senate CIO, and Kara McEwen, House CIO. House and Senate have been so supportive of us. So thank you to everyone who played a role in this. We are grateful, and that concludes my report, unless any members have comments or questions.
I got a comment, Madam Chair. Could I do it now?
Yeah.
Okay. Well, what I want to share with you guys is an email I received from another state agency about one of our employees, and they thought it not robbery to contact me to recognize this individual, and I told them that I would read the email. I forwarded the email to Curry, obviously, and also our legal, but I told them I would read the email so that they would know the value of the individual and to thank them for their service. And the email states, my sincere gratitude to Ms. Prime for her service. It says, Commissioner Newton, first and foremost, thank you for your continued public service in our community and the great state of Florida. I want to take a few moments to express my sincere appreciation to Emily E. Prime, Program Specialist / Financial Disclosure in the Office of the Florida Commission on Ethics. Emily's knowledge, professionalism, warmth, response time is a standard which our most exceptional public servant strive for, and Ms. Prime exhibits it time and time again. Over the past year, she has aided myself and several peers and members of the Juvenile Welfare Board with various challenges, questions, and concerns, some of which are quite complex. Despite all of us having different levels of knowledge and diverse skill sets, we have all been thoroughly impressed by her deeply appreciate her ongoing aid and extensive knowledge. Every time I reach out to Ms. Prime, it is a delight, albeit a surprise when we connect, simply because I cannot believe other agencies have not scooped up this remarkable, talented professional. Please express my sincere appreciation to your fellow commissioners for her service. And lastly, if Emily is an example of the standard of professionalism and excellence Ms. Stillman sets in her office, then clearly the Florida Commission on Ethics is in the very best hands. With gratitude, Rebecca Gross-Tiller. She's a director of public policy for the Juvenile Welfare Board. So I wanted to share that, and I want to thank Ms. Prime for her service. It's not often that we get accolades like this from an agency. Normally what you see in the paper about the Ethics Commission is, all bad. So I want to shine some light on the good, and you are appreciated. So thank you for your service. Thank you, Madam Chair.
Thank you for that. And if I might add, I do have plans next meeting to bring some staff here who've been working very hard and recognize their work. It was not uncommon during this disclosure season for me to receive phone calls from folks giving accolades to various members of the staff. And as you know, they work very hard, and they're a part of the magic. And so this did not surprise me at all. I'm very proud of the work that your staff does.
If I may just a brief thank you, ladies. And it sounded like one or two gentlemen, maybe. Is the whole department mostly women?
There are a lot of women, but there are certainly a good number of men.
Before you said you brought them in here and you were reading through, and I think it was maybe a 48-hour window between, sorry, we're sharing a microphone. And I'm going to take it over here. A 48-hour window from the court ruling to having to revamp and upload, and just doing the work I do, I know what that takes. I can't imagine the hours you had to put in those 48 hours to test, deploy, find bugs, put it back out. And so just thank you. It's remarkable.
Thank you for being here. It really was a remarkable effort, especially like you said, the turnaround time and, getting in compliance with that injunction so quickly it was wild how fast you all were able to do it, so thank you. And then I know I'm probably not alone in receiving positive feedback generally, anecdotally from folks about their e-filing process and how smoothly it went and how appreciative they were with the rollout of that. So thank you, everyone. I'm glad to hear that we'll have a chance to thank some more staff next time. Does anybody else have any comments before we move on? All right, and thank you again for being here. Moving on to item 5, we will move on to consideration of final action on a joint stipulation. This is complaint number 23-221 in Ray Ken J. Mascara. Will the parties or their counsel please identify themselves for the record?
Wayne Evans on behalf of Sheriff Mascara.
Thank you for being here.
Melody Hadley, Commission Advocate.
Nice to see you. Probable cause was found in this referral at our last meeting, and now we have before us a proposed joint stipulation between the commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or to reject the stipulation. If the stipulation is rejected, the parties cannot renegotiate and present a new stipulation at this meeting. The complaint would go to the Division of Administrative Hearings for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another commission meeting. Are there any members of the commission who need to make a disclosure regarding this case? All right, Ms. Hadley, you're recognized.
Thank you. In this case, respondent served as the sheriff of St. Lucie County. In the stipulation, he admits that he violated Section 112.3136 by using his position and/or public resources to secure a special privilege, benefit, and/or exemption for himself, and agrees to the entry of a final order recommending a civil penalty of $5,000 with public censure and reprimand. We respectfully ask for the Commission's approval of the joint stipulation.
Thank you. Does anyone have questions? Sir, would you like to be heard on behalf of the respondent?
I would just urge you to approve the stipulation.
Move approval, advocate's recommendation.
We had dual motions, and they were both the same. So someone.
I'll change mine to a second.
Perfect. All right. All in favor?
Aye.
Okay, thank you for being here.
Thank you very much.
Moving on to item number 6, consideration of a petition for costs and attorney's fees in complaint number 25-054 in Ray Fred Tricker. Mr. Tricker's petition seeks to have the complainant, Mr. Gary Shipman, pay attorney's fees and costs following dismissal of the complaint he filed against him. We have copies of the file in this matter and of staff's draft order denying the request. At this stage, we'll vote to determine if the petition is legally insufficient and dismiss it as recommended by staff, or find that the petition for fees is sufficient and should be sent to the Division of Administrative Hearings for a hearing as to cost and fees. Are Mr. Tricker, Mr. Shipman, or their counsel present?
I'm Fred Tricker.
Thank you for being here, Mr. Tricker. All right, Ms. Hayward will summarize the staff recommendation on the petition, and then we'll hear from Mr. Tricker, followed by, well, Mr. Shipman and his attorney are not here. So the parties are asked to limit their remarks to 15 minutes each, and after that, commission members are free to ask questions of either party or of staff.
Through the chair, Kathy Hayward for the commission. Thank you, Madam Chair. At the time the complaint was filed, Fred Tricker was allegedly a commissioner on the Walton County Planning Commission. You recently dismissed an ethics complaint filed against him because you found the complaint not to be legally sufficient. After the case was dismissed, the complainant, Mr. Tricker, filed a petition for attorney's fees and costs with the commission. And that's the first step one takes to recover attorney's fees and costs from the individual who filed the ethics complaint against him or her. The complainant's Gary Shipman. In the underlying complaint, the complainant alleges that Mr. Tricker was a commissioner on the Walton County Planning Commission and on the board of directors for the South Walton Community Council, which is a nonprofit organization. The allegation is that he was on both entities at the same time. The complaint alleges he did not disclose he was on the board of directors of the South Walton Community Council when matters that could affect the community council's interest were being voted on by the Planning Commission. The complaint also alleged that Mr. Tricker regularly voted in opposition to development in South Walton County, which was in accord with the South Walton Community Council's position of opposing development in the area. The complaint alleges that by failing to disclose that he was on the council's board of directors and by failing to abstain from voting on matters that could affect that entity's interests, he violated section 112.3143, subsection 3A Florida statutes, which is the voting conflict statute. The Code of Ethics allows respondents in ethics complaints to seek attorney's fees and costs from complainants if certain criteria are met. We have a rule that lays out the process for recovering attorney's fees and costs. This rule, 34-5.0291 in the Florida Administrative Code, states that the respondent must file a petition for fees and costs within 30 days of the dismissal of the complaint, and the petition must state sufficient facts and grounds to prove the person's entitlement to the attorney's costs and fees. If the commission determines, this is what Madam Chair was saying, that the facts and grounds in the petition are legally sufficient, it shall refer the matter to DOA for an administrative hearing. And if the commission determines that the facts and grounds are not legally sufficient, it shall dismiss the petition. Okay. Section 112.317, subsection 7, lays out the standard for determining whether a respondent is entitled to recover attorney's fees from a complainant. 3 criteria must be met in order for the person the complaint was filed against to be entitled to costs and attorney's fees they incurred in their defense of the complaint. 1, the complaint must be made with a malicious intent to injure the public officer's reputation. 2, the person filing the complaint must know that one or more of the allegations they're making are false, or they have to file it with reckless disregard for whether the complaint contains false allegations. And 3, the allegations must be material to a violation of the ethics code. If these criteria are met, the person who filed the complaint is found liable for costs and attorney's fees that the respondent incurred in his or her defense of the ethics complaint. It's important to note that the costs and attorney's fees we're talking about here are the cost and attorney's fees a person incurs specifically in their defense against the ethics complaint. The standard is not a prevailing party standard. It's a very high bar for recovery. And the reason it's a very high bar is because the intent is not to discourage complainants from bringing complaints that allege true facts that are material to the ethics violation, even if the immaterial details are false or simply can't be proven to be true. The law doesn't demand that every word and every detail written in a complaint be verifiably correct and objectively true. The Commission's legal staff recommends that you dismiss Mr. Tricker's petition for costs and attorney's fees for the following reasons. The recovery of attorney's fees in section 112.317, subsection 7, if all the other requirements are met, is limited to the recovery of costs and reasonable attorney's fees incurred in the defense of the person complained against in the ethics complaint. Tricker admits in his petition that he did not incur any attorney's fees with regards to the ethics complaint. He also never states that he incurred any costs related to the ethics case. He is seeking recovery of attorney's fees he incurred in an entirely different matter. That is, he's seeking recovery of the attorney's fees he incurred in his defense against an action brought to remove him from the Planning Commission. Mr. Tricker states in his petition that the attorney's fees and costs he incurred were for his assistance in preparing a response to his possible removal from the Planning Commission and, quote, not specifically to the ethics complaint. With regards to the ethics case, he simply says the legal advice would have been useful if a hearing on the ethics complaint had been required. With regards to his ethics case and the complaint brought against him, Commission records indicate that no attorney filed a notice of appearance or otherwise took part in the defense of his case. Rule 34-5.0291, subsection 2, Florida Administrative Code also requires a petitioner to include the amount of costs and fees expended by them in their ethics case in their petition for fees. The petitioner did not state he had incurred any costs or fees in its ethics case, or include documentation of cost or fees he incurred regarding his ethics complaint in his petition. He just provided the amount he paid the law firm with regard to his defense against the action to remove him from the Planning Commission. Since Mr. Tricker did not expend any money on costs or attorney's fees in his ethics case, by law, he's not entitled to recovery of any costs or attorney's fees in this case. And then while there's no need to go into a discussion of whether the merits of his arguments would be legally sufficient to state a claim for costs and fees, the draft does continue with a discussion of the merits of his arguments. Commission legal staff conclude that the arguments in the petition are not legally sufficient to state a claim for fees and costs even under the merits, and recommend that the petition for attorney's fees and costs be dismissed on the merits as well. The draft fully explains the reasoning for that. I also have materials up here if you have further questions. You're not obligated to adopt this draft order. It's just a document communicating the staff's recommendation to facilitate your consideration of the matter. I'm available if you have any questions.
Thank you very much. Mr. Tricker, would you like to be heard?
Yes, I'd like to speak.
Please, by all means. Yes, sir.
Never been here before. I'm not real clear on what the procedures are, but I'm learning fast. Thank you for the opportunity to come and speak this morning. I think this is an important issue for me, so I want to explain my position here. We're not talking about a lot of money. I didn't spend a lot of money on legal fees, but it's a matter of principle for me. The whole ethics complaint was very offensive to me, and it was issued with malicious intent. So I'm going to talk about that a little bit. So first of all, background, the ethics complaint is directly linked to an attempt to have me removed from the Planning Commission in Walton County, where I've been serving for 3 or 4 years. And I think I've had an impact on the Planning Commission because before I got there, Planning Commission was a rubber stamp organization. And so I have been a thorn in the side of people that are trying to push through development that I don't agree with. So I've been very vocal about that. And that's why Mr. Shipman wanted me removed from the Planning Commission. So the background is that I got a call from Commissioner McCormick, Boots McCormick, in early February of this year. And he called me to tell me that he was replacing me on the Planning Commission. So I said, okay, that's your prerogative. And so that was the end of our discussion. He didn't give me any reasons for it. I didn't ask for any reasons. But then he went ahead and brought it up at the next Board of County Commissioners meeting, where there was a motion and a second to remove me, and he had the votes. But then one of the other commissioners stood up and said, well, you can't just remove a planning commissioner. There's a procedure for that, is you have to have written charges and you have to have a public hearing. And so that was a surprise to Mr. McCormick. I think he wasn't prepared to do that because he wasn't aware of the requirements. And it was a problem for him because he didn't have anything against me. There was never anything that he alleged that was said that anything I did at the Planning Commission was improper or he wasn't happy with. He never said that. And it wasn't personal. At the public hearing, he said publicly it was nothing personal against me. He has never disclosed his reasons for wanting to have me removed. So anyway, the next step in the process is there was a public hearing in early April, and at that meeting, for that meeting, actually, I did prepare a response, and that's the reason I hired an attorney to help me with the response. But I would like to say, first of all, that the ethics complaint contained charges related to my association with South Walton Community Council, which is a nonprofit. And so I've been involved with them for a number of years, for quite a while. And so the allegation was that there was a conflict of interest with my duties as a planning commissioner, which I don't believe is valid. And before I accepted the position, I checked with the county's land use attorney, and he advised me that that's not a conflict of interest. If it's a bias that I have related to, if it's I can't remember that word. If it's non-financial, then it's not a conflict of interest in terms of ethics. So he cleared the way for me to join the board, which I did. And so the thing I want to talk about is that the ethics complaint, like I say, is mostly about my association with South Walton Community Council. The written charges, which were developed at about the same time that the ethics complaint was submitted in March, contain all the same allegations. It's all the same thing. So when I hired a lawyer for the Planning Commission removal hearing, it wasn't just the Planning Commission removal. It was mostly about the ethics complaint. And at the at the public hearing, I made a statement that I never wanted the job as a planning commissioner. I accepted it only to help out Commissioner McCormick, and only on a temporary basis. I didn't want the job, and I still don't want it. And that's true today. I don't want the job, but I'm doing it because I think I have to. So I would never have spent legal fees to defend myself from being removed from the Planning Commission. I would never have done that. It was always about the ethics complaint, which I did take very seriously. I did take offense to, and I could not let that stand. So if you look at the response that the lawyer did, that's what it was mostly about, was about that issue. So the ethics complaint was nothing but a pretext to achieve an objective that Mr. Shipman made very clear in a letter he wrote to the BCC, Walton County BCC, in March, which stated that he just filed this ethics complaint and this is what it's about. And right at the bottom he says, and we must remove Mr. Tricker from the Planning Commission. So that was his goal. And it aligned with what Boots McCormick was trying to do. So they conspired. I found out later they actually had 2 meetings on the issue. So these 2 guys are working together to try to nail me. But the ethics commission, ethics complaint, I believe very strongly was nothing but a pretext. I don't think it was real from the very beginning. So yeah, so I said in my petition for costs that the lawyer I hired strictly for the planning public hearing, but I did say in there actually that they're linked. The 2 things are linked, and I think they're directly linked and directly related to each other. And the money that I spent was not to defend myself against being removed as a planning commissioner. It was for the defense of the ethics complaint, which at that point in time, I fully expected there was going to be a hearing. So I had to get prepared for that as well. So that's why I spent the money on it. That's what it's all about. So Do y'all have any questions for me?
Does anyone have questions? Thank you for your time.
All right, thank you very much. Appreciate it.
I have a question for Ms. Hayward. I have a question, yes. Having heard the presentation by Mr. Tricker, which I think does add some facts that maybe aren't in the petition with regard to what the attorney's fees were spent on. Do you have any sort of response to those additional facts in substance, or whether we can consider them, or does it change your analysis at all?
I have a response to that. I would say it does not change the analysis. There are kind of two prongs to this. The first is they have to establish that they spent attorney's fees. So sorry, and that should be in the petition what the amount is. But if you want to find that he did, some of the legal fees he spent were related to the ethics complaint, that could satisfy the first prong, that they were spent. However, in order to, in the rule is cited in the draft opinion. Both the rule and the statute are on page 2. And so once you get past the issue of whether legal fees were expended on behalf of the complaint, you would have to find, in order to find the complainant liable this is the statute, section 112.317, subsection 7. He would have to establish that the complainant filed this with a malicious intent to injure the reputation of Mr. Tricker, and filed the complaint with knowledge that the complaint contained one or more false allegations, or with reckless disregard for whether the complaint contained false allegations, and the allegations have to be material to a violation of this fact. And when you look at Mr. Tricker's fees, which is an email, one-page email, he never specifically says anything was false. The things, if you'd like, I can read his entire 7 points. The closest he comes, he says the complaint was a malicious attempt to have me removed from the Planning Commission. And then he says it was filed with reckless disregard for whether the complaint contained false allegations. But he never says what those false allegations were. I'm not sure that he said that today either. He never says specifically, that what the false allegations are. And I think to meet that standard, the high standard, not just that someone prevailed, he has to show that he filed it with knowledge that it wasn't true. And what he's saying essentially is just, he was on both boards. He voted that in the interest of one of the boards. So my criteria, my recommendation would be that he did not meet that second prong of establishing that. Okay.
Thank you.
You're welcome.
Does anybody else have any questions or anything for discussion?
Discussion? The petition to me is equally as conclusory as were the allegations that were dismissed as being insufficient. And while I am sympathetic to anyone who has to expend money for allegations that they dispute, we live in a world where there are sometimes multiple actions resulting from the same set of facts. I just do not see how we have any option other than to dismiss this petition as not being well-founded under what the statutes require.
I tend to agree. The statute is, it's a very demanding standard for malicious intent, and I will echo the sympathy for having to expend the fees. I do wonder though, if is it possible to add sort of the alternative basis in the draft order, that the second prong, sort of, because I think, does the draft order address the, the draft order is focused on where the fees are expended. I don't know, I'm looking through it again now, whether it states sort of that, alternatively, even if they were alleged to be expended in connection with the ethics complaint, they don't,
Madam Chair, it's the footnote 1 covers that.
oh,
pretty well.
okay, thank you.
Yeah.
Thank you. Okay. Right, okay. So particular, okay. Is there any, and thank you, Ms. Hayward. Is there any other discussion or questions? Is there a motion?
Accept the recommendation. Second.
Okay, all in favor?
Aye.
Aye. All opposed? All right. Thank you, Ms. Hayward, and thank you, Mr. Tricker, for being here. We appreciate your appearance. All right, moving on to item 7, consideration of financial disclosure appeals. The first item that we'll consider is a matter in which a hearing was requested. That is case number FD 22-001 in Re George Sanchez. That is, if I would have read my outline, I would have remembered that yesterday, Mr. Sanchez rescinded his hearing request. So this is what happens when you don't read ahead. So never mind. We'll move on to consideration of financial disclosure appeals in which no hearing is requested, including FD 22-001. So this is all the remaining items under 7. So these are appeals of automatic fines for failure to timely file annual financial disclosure forms. None of the listed appellants requested to be heard, so there will be no oral presentation on the content of these appeals unless a member requests it. Are there any members who need to make a disclosure for the appeals listed under items 7A and B, including Mr. Sanchez? And are there any questions from the members on any of these appeals? If any member would like to have staff present drafts for consideration, please indicate so now. Otherwise, we'll entertain a motion for all of them as a group. Is there such a motion to entertain items 1 and 1 through 5?
I make the motion.
Is there a second?
Second.
Okay, all in favor?
Aye.
Aye. All right, moving on, item number 8, consideration of the 2025 meeting schedule, which we are handing out now.
Ink is still wet.
Commissioners, you were emailed an updated copy the other day of this proposed meeting schedule. The dates that were originally sent to you remain the same. We just are in a continual process of looking at our practices as we prepare to implement the remaining parts of Senate Bill 7014 on October 1st. So we made some adjustments to our internal processes and deadlines, and that was the change made to the document. But other than that, the dates remain the same in terms of the meetings. It's just our internal markers.
All right, does anybody have any questions or concerns about these proposed meeting dates? If not, is there a motion?
Second.
Okay, all in favor?
Aye.
Alrighty. Can we keep this?
Yes.
All right, there is no chair's report, so moving on to the executive director's report.
I don't have much to add to my written report, except I did want to introduce to you a new member of our staff. Emma Wade is with us in the audience. Emma, can you stand up so they can see you? She is a student and a part-time clerk in our office, so when you call, one of the pleasant voices that you will hear is Emma's, and we are really happy. So please welcome her to our staff.
Thank you for being here.
That's all that I have.
All right, is there a motion to adjourn?
So moved.
So moved.
Is one of those moved to second?
Yes, it is now.
All right, all in